Welcome to In Plain View, and I am your host, Claire Huxtable 2.0. It is Supreme Court Saturday, so you know what that means. Let's go and see what the Supreme Court had to say about some of our rights. Tonight on the docket will be a case that provided an exception to your Fourth Amendment right against unreasonable searches and seizures. That exception is brought to you by John Terry and the state of Ohio, specifically Cleveland. As always, I go into the tea on how the case came to be, and then we get into the legal stuff. So come with me, if you will, to Cleveland, Ohio, 1963. All right, so Cleveland, Ohio, 1963. Officer McFadden is on his regular beat, but he is in plain clothes. He notices while on his beat, two black males in front of a storefront, pacing back and forth and peeking into the window of the storefront. Officer McFadden observes this about 12 times before he decides to approach the gentleman. When he approaches the gentleman, he inquires as to what they're doing in front of the storefront. The two gentlemen, now known as Richard Clinton and John W. Terry, give him something of a mumbling answer. Unimpressed with this answer, Officer McFadden decides to go ahead and arrest them. He spins them around, pats them down, and during the pat down, he finds two pistols, one on Richard Clinton and one on John W. Terry. Because they were found to have been carrying a concealed weapon, which in the 60s was a big deal, especially if you were black. Think about this, 1963, no civil rights yet, y'all, okay? So they get arrested for carrying a concealed weapon and they end up at trial. During the trial, John W. Terry's lawyer asserts a motion to suppress the evidence, namely the pistol found on John W. Terry. His lawyer argues that under the exclusionary rule that was holding in a previous case, Mapp v. Ohio, the gun that was found during this search cannot be used as evidence in this trial. He does so to no avail because the court is not having it. They end up convicting John W. Terry of carrying a concealed weapon, and they sentence him to 3 years in jail. Of course, the lawyer is not pleased with this outcome because he really believes as though the gun was seized during an illegal search and should never have been used. And but for the gun, there would be no case, okay? He then goes on to file 3 appeals. One goes to the District Court of Appeals in Ohio, where he gave the same spiel. Under the exclusionary rule, you cannot use any evidence that was seized during an illegal search against a defendant in his trial. The District Court of Appeals in Ohio was not here for it. They affirmed the lower court's ruling. Not counted out, though. The second appeal, he goes to the Supreme Court of Ohio and tells them the same thing. Under the exclusionary rule, blah, 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 blah. The Supreme Court in Ohio says, not happening, case dismissed, right? So what he does then is he goes to the Supreme Court of the United States and gives them the same rundown. Exclusionary rule, can't use the evidence, blah, 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 right? So the Supreme Court was like, we'll take it up on a writ of certiorari. So a writ of certiorari is where the Supreme Court or the higher court goes down to the lower court, gets the record, and reviews the matter, right? So after they do the writ of certiorari and they give it a review, they still say, nah, the evidence stays, conviction stands, okay? But they will tell you this. Here is why it stands, and they went into their whole decision. The decision said, in pertinent part, yes, the exclusionary rule is a protection against unreasonable searches and seizures in that if you perform an illegal search and seizure on a person or their property, anything you find will be excluded as evidence and not used as at trial. However, different circumstances count when it's a police officer and they are protecting their safety or preventing a crime. They use the term reasonable person, reasonable suspicion. In that, if a police officer has reason to believe, under a reasonable, prudent person standard, that a crime has been committed or that an individual is preparing to commit a crime, They can approach, search to protect their safety, and whatever they find is fair game. Now, I'll get to the gray area of that in just a moment. So here's where it gets gray. Terry versus Ohio came out in '66 after 3 years of John Terry serving time in jail. But we know in recent decades, and even decades between the '60s and now, the reasonable suspicion standard that was handed down by the Supreme Court has since been warped to predominantly mean the arrest and detainment of people of color, specifically Black and brown defendants and suspects in highly populated metropolitan areas where there is a significant amount of minority residents. Law enforcement has taken the reasonable suspicion standard and used it now as a weapon and on a whim. This has led to higher convictions, recidivism in jail, and also cost people their lives. So that is the story of the Terry Frisk, aka the Stop and Frisk. Make sure to like, share, subscribe to this video. Next up, we're going to talk about the right to have sex with the same sex. Talk to y'all later.